May it please your lordship. My lord, I beg to mention item number 5, your lordship. The other side has filed already affidavit, your lordship. I am willing to file rejoinder, your lordship.
Okay.
1 week time.
Mr. A81, learned counsel for the petition has paid for and is granted 2 weeks time
2 weeks time.
to file an affidavit in reply to the affidavit in opposition filed by the respondent number
2, your
State.
lordship. Respondent number 2, your lordship.
respondent number 2. Okay, Mr. P. Medhi, P.K. Medhi,
Yes, sir.
you are for
Government.
for the okay. For the respondent number 2 is present. After release the case after 2 weeks from the date.
Much obliged. Deep obliged, lordship.
My lord, I beg to mention for very urgent petition, my lord. That may, I beg to mention very urgent petition, my lord. That may be taken day after tomorrow, my lord.
Day after Friday.
Friday.
May it please your lordship, my lord, with the consent of the other side, I beg to mention item number 1 of the daily list, my lord. My lord, the briefing council to the learned advocate general is in bereavement, my lord. I pray for 1 day accommodation, my lord. Tomorrow, if possible.
Okay. When?
Tomorrow, if possible, lordship.
Tomorrow. Day after tomorrow? Day after tomorrow?
Yes, lordship.
Okay. MS
R.
Guru, R. Guru, Senate Council appearing for Mr. D. Hokia, advocate some has sought for listing of the case on Thursday. Mr. B. Chakraborty, Senate Council for the petitioners, has is present and has no written for the state fair. List the case on
11
day
on.
after tomorrow.
Deep down.
May I please, your lordship? Lordship, I beg to mention listing a writ petition, lordship, day after tomorrow.
What is this admission?
No, motion, lordship.
Motion, Friday.
Obliged.
May I please, lordship? Lordship, I'm praying for listing of a writ petition, my lord, for tomorrow, my lord. Matter relates to the eviction.
Motion,
Yes, my lord. Eviction,
Motion.
my lord. Matter-
eviction.
Eviction, my lord.
Okay. You have filed.
Yes, my lord. Today I have filed. Obliged.
Listing for withdrawal, my lord. Contempt.
Lordship, may I please mention the item number 11. Here, conducting counsel Ali is not well and he is not in Guwahati. So
Okay.
kindly pass over the
Mr.
C. Talukdar.
C. Talukdar, Land Council appearing for Mr. A. Ali. Has submitted that Land Council for the petition has submitted that Mr. A. Ali is indisposed and has paid for listing of the case after a week. It is submitted that consent. You have informed the other side.
Yes.
We submitted that consent has been taken for the Land Council for the other sides to make that fair. Mr. J. Hindu, Planet State Council. is in
Last
attendance.
several occasions they are absent. Lordship
What has happened to A. Ali?
He got kidney transplant in
then
but he come to Guwahati, but he left
He
it not in
is
native
suffering
place.
from kidney ailments. Because 2014 matter,
Lordship.
he is suffering from kidney ailments and has paid for listing of the case up to 2 weeks.
Deeply obliged.
For motion item number 2,
It is issued to you.
Me, please, your lordships. Your lordships, in this matter, I'm led by Senior Counsel Mr. T. Das. He's on legs in another court. It is not inconvenient, kindly the matter be to pass over for the timing.
almost 12 and 13.
May I please, your lordship? I'm led by Mr. D. Das and he's in legs, lordship.
We can start stating the facts.
Yes, yes. Lordship
You
is
are
only
quite aware of the facts.
Lordship only remanding the matter to the authority. Yes. Dispute only.
আৰু এটা আছিল না
One more thing.
I have found one letter of the circle officer addressing to the deputy commissioner asking for his advice or something like that somewhere. Have you seen that?
In the instruction or in the pleadings?
Maybe in the pleadings or in the instruction. Instructions, Mr. Somewhere I have seen.
According to this instruction, at page 121,
Huh?
at page 121 of additional affidavit.
Hmm. 121 and particular 123
Yes.
of the first repetition, perhaps
Second rate.
second repetition. Yes, Sharma, instructions.
Yes, sir.
Let me recapitulate the facts first.
Yes.
Okay.
Is that the two instructions, but the instruction is same lot?
Both the repetitions. That's WPC number 1219/2023 and WPC number 7210/2023, are prepared by the same two petitioners. Under Article 226 of the Constitution of India. Full stop. Subpara. The first read petition, WPC number 1219/2023 is preferred after issuance of a notice dated 18/8 is prepared in connection with a notice dated 18/8/2022 issued by the respondent number 3, that is the circle officer, Dispur Revenue Circle, Kamrup Metro. Where is that notice?
Page 70 of the first letter, Lordship.
The notice dated 18/8/2022 was issued in respect of issued pursuant to an application submitted by the respondent number 4, that is Dispur College, within bracket hereinafter referred to as the college. For settlement of a plot of land, government land, full stop. In the notice dated 18/8/2022, which was addressed to the petitioners as the possessors, and wherein the college has been shown as the applicant, comma, the petitioners were informed that the college has applied for settlement of a parcel of land measuring 6.60 hours which 60 hours, comma, which comprise of 1.60 hour in government dag number 141 and 5.00 hour in government dag number 146. The notice further informed that indicated that as per report of the Latmondal, comma, the applicant college does not have the position in the said parcel of land measuring 6.60 R, and it has been reported that the petitioners are occupying the said parcel of land by constructing an Assam type house and a house constructed by teens stroke tarja. Full stop. By indicating so, comma, the respondent number 3 mentioned that a hearing on the subject was necessitated and the petitioners were asked to appear before him on the scheduled date with all the supporting documents. Full stop. Paragraph. The second writ petition, WPC number 7210/2023, has been preferred by the same petitioners when they were served with a an eviction notice dated 29/11/2023, comma, issued under the hand of the respondent number 3, comma, purportedly under Rule 18(2) of the settlement rules framed under the Assam Land and Revenue Regulation 1886. By the said notice dated 29/11/2023, it has been mentioned that the petitioners are in unauthorized occupation of the parcel of land covered by government DAG numbers 141 and 146 of village 2 number Dispur, Moja Beltola. Full stop. By serving the notice dated 29/11/2023, the petitioners were asked to vacate the said parcel of land within a period of 14 days from the date of receipt of the said notice dated 29/11/2023. Full stop. Para. From the petitioners from Nalagam. The petitioners have projected that their owners of 2 plots of land which for convenience are referred to here, are herein referred to as land A and land B respectively. Land A. Where is the page 61?
61. Map.
What is the description of this top left hand plot of land in a repetition? Because I get confused with dark number, pattern numbers.
Page 15. 14, page 14, para 15.
Starts from page 14.
Okay.
Para 15.
Land A is stated to be comprised of two dark numbers, 177 and 234. Most of the petitioners have stated that these are old dark number or what? Old.
Old.
Yes.
Old, huh? Records. The petitioners have stated that this land A belongs to the petitioners and their family members. And after a last settlement operation, the old dark number 177 has been renumbered as dark number 727 and 728. Full stop. Subsequently, the land covered by dark number 727 and 728 have been bifurcated into dark number 727, 728, 931 and 932. On the other hand, the old dark number 234 has been renumbered as new dark number 931 and 932. Subpara, land B. It the land B was originally covered by dark number 19 old. Full stop. Subsequently, dark number 19 old has been bifurcated into two dark numbers, 134 and 138, right? Full stop. The petitioners have claimed that as per the periodic patta, land B is the area under land B is 2 bigha, 18 lessons. Land A and land B. About these school college. You haven't repeated in the earlier petition.
Yes. Thank you. Equal.
On the other hand, comma, the respondent college has taken claim in respect of 2 plots of land which can be, comma, for convenience, which are for convenience referred to hereinafter as land C and land D. Is 60. Land C. It comprises of dag number 38, whole. And area.
And it page
And its
65.
area of land.
Area
Page 65.
Tell me.
1 bigha 2 kattha.
1 bigha, 2 kattha. Land D. What is the allotment?
Documents are not. Lordship, it is in the settlement officer report that is at page 65.
Of the first petition or second petition?
Second petition, Lordship.
Land D. It pertains to dag number 18 old.
18 of 2 bigha 3 kattha 2 lechas.
And
18.
its area is 2 bigha, 3 kathas, 2 lesser. The para. The 2 sides. Are at loggerheads as the four plots of land because of the location of the 4 plots of land. Full stop. The 2 plots of land, that is land A and land B, comma, in respect of which the petitioners have stake claim, comma, are diagonally opposite, and the other 2 plots of land in respect of which the college has stake claim, that is land C and land D, are also diagonally situated. Full stop. As a result, comma, the two sides had a common intersection between the four plots of land. Insofar as the two diag numbers mentioned in the notice dated 22/8/2022 and the notice dated 29/11/2023, that is diag number 141 and diag number 146, neither sides has claim ownership as the respondent number 3 in the said notice has mentioned that those two diag numbers belong to the government. Full stop.
I have
Government,
another instructions regarding that tag number 138, 134.
what is that? Tell me. What instruction? First you read and tell me.
Then also it is stated that with reference to the order dated 20/12/2023 past WBC 7210, it is submitted that accessibility to DAG number 138 and 134 can be made to the government DAG number 729, 140 and 141.
Don't know about those.
Last time it was from the map.
No, there are three trace maps. Every trace map projects different DAG numbers. We are not going into it.
Let the field authorities take a call, madam.
Two things, that college should have the land and the petitioner should have accessibility to the road, which the deputy commissioner.
Well, at least we being a founder member, I told my learned friend, you have to leave for the public interest. I have seen 721, 729, 729, 140, 141, there can be a road. There can be road outside it. So there will be no problem. There cannot be like intersection will go. So there is a road which is outside it. So that let all the parties be present and we can develop that also. There is absolutely no problem.
The petitioner side have alleged that these two DAG numbers, that is DAG number 141 and DAG number 146, were not in existence at an earlier point of time. And those DAGs might have been created later on. Full stop. It has been contended that a college side has put an obstruction in the at the intersection. As a result, the petitioners, the ingress and egress to land B through land A has been blocked. Full stop. On the other hand, the college side has contended that even the intersection is closed, the ingress and ingress to land B has not been blocked. The petitioner can have access to a road, public road from land B itself. Full stop. The response number 3. In his communication hearing number DIS-4 stroke 2018 stroke 4 stroke 3032 dated 19/12/2023 has mentioned that as per the land records available in his office, government dag number 141 comprises of 1 katha 19.96 lessas and dag number 146 comprises of 2 bighas 2 kathas 5.54 lessas. And an area of land measuring 6.6 hours out of the said 2 dag numbers are found in possession of the petitioner side. And the petitioner side has constructed an Assam type house and Teen Sali Torja house in that area measuring 6.6 hours, 60 hours. Where the 3 trace maps produced during the course of the proceedings by the sites project different pictures as regards the location of various dag numbers, including land A, land B, land C, and land D. Full stop. Perusal of those test maps from perusal of the test maps, it is difficult for this court to arrive at any concrete, any definite view as regards the claims and counterclaims of the contesting parties. Full stop. The petitioner side has alleged that after by the notice dated 22/8/2022, they were called for a hearing, and during the course of the hearings before the response number 3, they had submitted all the supporting documents as regards their claim in respect of land A and land B. Full stop. The petitioner side has further claimed that they have been the petitioner side has been using the intersection since a long period of time for ingress and egress to land B through the intersection and through land A. Full stop. The college side has come on the other side and has contended that it is a public educational institution and for conduct of its affairs, the dispute as regards disputes raised by the petition side needs an early resolution. So the college side has further contended that there should not be any disturbance to the academic atmosphere of the public educational institution. Full stop. It has further claimed that in land D, it is contemplating to construct a girls' hostel. Is it so?
Yes.
Before that, college side Ragot, the petitioner side has contended that despite support or despite placing all the supporting documents.
Girls hostel is already been constructed. It's there.
Has a girls' hostel in land D. Land D? Land D.
Dag 18.
Already has a girls' hostel in land D. During the course of the proceedings, college side the petitioner side has contended that despite placing all the supporting materials, including the land documents, the respondent of a plea, without coming to a definite conclusion, has issued the eviction notice dated 29/11/2023, which in the fact situation obtaining, is uncalled for. College side.
My lord, just to keep our perspective, according to us, my lord, land A is totally Sarkari, which they are encroaching. That may be my lord incorporated.
The college side has further contended that land A, in respect of which the petitioner side has taken claim of ownership, is not cannot be countenanced as the said land A is government land.
Because my lord, the document which they've annexed in the additional affidavit, the note shows, my lord, based on possession, my lord, mutation. What is this, my lord? There's no title.
No, we have a sale deed, my lord. We have brought into it because that was not an issue. Issue was in respect of 138. We have got that.
During the course of the proceedings, this court had called for instructions from the respondent number 3 as regards the exact locations of the 4 plots of land and as regards the dispute relating to the intersectional point. This court has also sought instruction as to whether, in case of any blockade at the intersection, there would be any whether the petitioner side. No, sorry, there would be whether due to blockage on the register, there be no ingress and egress, point of ingress and egress for the petitioner side from land B. Also. Where he says that, in which instruction, Mr. Sharma, that some dark numbers, access could be access.
This is,
No, he said, that has not said there is access. He said it could be access.
yes. Yes,
Can be.
can be made.
Can be. Which one?
2/1/2024.
2/1/20.
2/1/24. And in
The respondent number 3 provide his communication bearing number so and so dated 2/1/2024 has reported, has submitted that there could be, the accessibility to DAG number 138 and 134 and 138 within bracket, land B, can be made through government DAG number 729, 140 and 141. Full stop. Such instruction does not throw any light as to whether, in case of any blockage at the intersection between the 4 plots of land, there is still point of ingress and egress to a public road from land B. Which letter, Mr. Khandelia, that Deputy Circle Officer writing to
121.
Deputy Commissioner?
Page 121.
The vernacular is at 123.
Yes. I am reading the particular only. He is commenting against you also. College, you are occupying there 138.
My lord, we say that the plot which is under their occupation is a government land, please allot us. It's a public purpose, that's all.
No. There is one line.
Ah.
Anhate Kheras
Ah.
near the Soinong Pottar 138
Dispute
Dakar
হবে, দখল থাকা দেখা যায়।
Ah.
No, we have been allotted land by the government, my lord.
He could not solve the issue, that's why it was sent to Deputy Commissioner.
Most importantly, my lord, the possession was handed over by the concerned Mondal, my lord. That is how we are occupying. Maybe, we are not disputing. The question of public interest vis-a-vis private interest.
I think after construction of girls' hostel in land D, the issue of exchange of land stands closed. Did not.
No, my lord, that process we have
We have abandoned.
We have abandoned.
So we are not referring to that.
So they started initially, thereafter they abandoned. They started initially.
But now there is a guards hostel also.
No, we have abandoned that.
We will not refer to that. That will create more confusion.
My lord.
Otherwise, all this land dispute is not a case of repetition. Why you have brought this Rajkumar join issue?
Lordship, we have stated that our possession was time and again verified by the revenue authority because there was a dispute at that point of time also. At that time, the revenue authority verified and found that we are in actual possession. Only in that respect, Lordship.
From a perusal of the eviction notice dated 29/11/2023. From a perusal of the contents of the eviction notice. It transpires that the said notice has been issued by the respondent number 3 on the basis of knowledge gathered from a report of a Latmondol, wherein it appears to have been reported that the petitioner side is in unauthorized occupation of government Dag number 141 and 146. That was the having regard to the
Lordship's kind permission, can I take leave? My friend will be there.
claims and contract claims of the two contesting sides and the disputes of the two sides on the basis of the documents placed by them, comma, a number of disputed questions have fallen for consideration. Full stop. Without this court is of the clear view that the disputes raised by the parties cannot be adjudicated without a thorough field inspection and detailed examination of the revenue records, land stroke revenue records pertaining to land A, land B, land C, land D, and all other plots of land adjoining these four lands. Full stop. The the two contesting sites have sought resolution on two main issues. Comma. Full stop. The petitioner side has apart from other issues, apart from the two concerns has sought resolution on two main issues. The petitioner side has submitted that the petitioner side should have proper access to a public road proper and peaceful access to a public road from land B, which could be either through the intersection and lane A or through any other route as indicated by the circle officer
Yes.
in his communication bearing number so and so dated 2/1/2024. That is through government DAG number 729, 140 and 141.
Right.
Either of the two.
Yes, yes.
On the other hand, the college side has contended that the college should have full access to land A and land C without any interruption from the petitioner side. That's all.
C and D. Then
C and D. C and D. Without any kind of interruption from the petitioner side. Full stop. This full stop. Notwithstanding the other issues, even for resolution of the aforesaid two main issues raised by the two contesting sites, a field inspection, a detailed field inspection in the aforestated manner is of is a necessity. Full stop. As apart from a detailed field inspection, inspection stroke enquiry, a thorough examination of the land stroke revenue records are also found necessary, this court having regard to the disputed questions of fact does not want to is not required to embark on an fact-finding inquiry as the same false, clearly false within the ambit, authority and jurisdiction, ambit and authority of the jurisdictional deputy commissioner. Full stop. For the purpose of carrying out such field inquiries, inspection stroke inquiry, and examination of land stroke revenue records, the jurisdiction deputy commissioner can get assistance of all the revenue officials, including respondent number 3, and also the assistance of the 2 contesting sites. Full stop. Though ordinarily, the extraordinary and discretionary jurisdiction under Article 226 is not to be exercised in a matter where a number of disputed questions of facts are involved, the aforesaid exercise is found to be called for, considering the fact that one of the constituting sites is a public educational institution, and if a resolution of the 2 issues are not arrived at without contest, without undertaking such exercise, the petitioner side might not have access to a public road from land B. So stop. In such peculiar fact situation obtaining in the case, this court is of the considered view that a direction to the jurisdictional deputy commissioner can be made to undertake the exercise as indicated above, so as to make an attempt to resolve, to reach, so as to make an earnest endeavor to resolve the issues raised by the 2 contesting sides. Resolve at least the 2 main issues. At least the 2 main issues only. Only 2 main issues. Resolve at least the 2 main issues at an early date in an expeditious manner. It is accordingly directed. Full stop. While undertaking the exercise, in the said, it is observed that during the while carrying out the said exercise, comma, the jurisdiction deputy commissioner, that is the deputy commissioner, Kamrup Metro, or an authority delegated to undertake such exercise, comma, the two contesting sides should be provided with all the opportunities to represent their cases on the basis of the supporting documents available at their ends. Yes, Sharma, within what time? Basically, two issues. If circle officer can give access to the petitioner's land B by that government DAG number, carve out a road, that's all, if possible.
3 months, I think.
3 months?
No problem.
Maybe that within
It is not easy. You are contesting for so many months. Government machinery moves. I don't know. Then in the meantime, election may come.
No, yes, Lordship, that's because some
Election
of
may
the
come.
officers are Lordship, they are engaged in this election.
And what about the access in the meantime? Mr. Sharma Learned, additional senior government advocate, has submitted that a period of 4 months would be a reasonable period to undertake and complete such exercise. Yes, what about the dispute as going on at present?
I know what we feel, that excess flow should fill then only.
Till completion of such exercise, comma, the respondent authorities shall not take any exercise contemplated by the eviction notice dated 29/11/2023. That's all?
Yes. I think they can solve the issue because the last letter, because I have seen that map, it can be outside.
It is having regard to the issues raised by the two contesting sides, comma, it is expected that the two contesting sides would render all the assistance and cooperation to the jurisdictional deputy commissioner, district commissioner, during the course of the field inspection stroke inquiry.
Clear.
Don't fight. Disposed of. With the above observation, with the above directions, the repetition stands disposed of. If you are agreed, go to civil court, don't come.
We try to solve the issue.
Yes.
But
Only
by
two
not, by not going to any court.
That is why I said I have peculiar facts and circumstances, because one is public institution. You are raising that you have no access. Only that is the issue. Other issues you find it out
Yes.
somewhere else, not this forum.
Yes, of course.
We'll take up your GST case after some time.
After,
There are other motions.
I will do other case, then I will come.
Item number 14. 12:13, I can get a response number 1.
Okay. Repeat query over here, Kira. DDAS assisted by so and so. J. Hendik, Standing Council Revenue, 1. H. Sharma, additional senior government advocate, 2. And a circle officer, deputy commissioner, circle officer. Aruk K. Chaudhary, senior counsel assisted by D. Chaudhary for the response number 4. I go to side level, J. Hendik to whom I live. Yes.
Lordship. In this case, Your Lordship, I have challenged the eviction notice. Your Lordship, it is start from 37.
Wait, tell me.
Page
Which
42.
notice?
Page 42, Your Lordship.
Page 40?
42, Your Lordship, particular.
Vernacular 27. Yes.
In this case, Your Lordship, this notice has not issued under any provision of law, Your Lordship. One thing, Your Lordship. Another thing, Your Lordship, the ground for eviction, it is not acceptable, Your Lordship, because there is no proper verification or field verification this notice is issued. Because my resident is more than 120 feet distance from the road. And there is some Pattahadas road is there, Your Lordship, nearby the road, but there is no notice has given to them. And moreover, Your Lordship, Pattaland is adjacent to our land and some others land.
You are in occupation of what kind of land? Patta land or
No, Your Lordship.
government land?
Government land. Yes.
Government land.
For more than 60 years, we are occupying and.
Whatever, that
Lordship.
encroacher is always an encroacher.
No, Your Lordship, we are paying
But
the land.
what kind of notice is this?
There's a notice is not.
Under what provision?
Nothing.
Lordship, because they are occupying a government landlord,
Right,
and
right.
because of that, there is every possibility of, from that, it's shown that there is every possibility of some road accident.
Having a look at it,
Lordship,
three things have been noticed. That there is no mention of any provision.
Lordship,
Secondly, there is no provision of any particular land details.
Lordship,
There and this, whether assistant settlement officer is empowered to issue any kind of eviction notice. These three things are apparent from a look of this land details that yes, you are occupying one katha land under
Under the government DAC number so-
Oh, that must be there. Under what provision of law? This man, he is sought to be evicted. Kader Ali, Ponsorotno. And thirdly, under settlement rules 18, deputy commissioner or nowadays circle officer, they are empowered.
Lordship,
But assistant settlement officer is different authority.
that is true, Lordship.
You should approach properly.
Lordship.
He is encroaching government DAC. You are entitled to
Lordship,
undertake eviction exercise. But thing is to be done in that particular manner.
Lordship,
Land details are not there. Person details are not there.
No, disposable করে দিবেন। It can be disposed of, Lordship. Because apparently.
Yes,
Lordship-
Mr. Henrik and Mr. Sharma, if say that you'd undertake proper exercise,
Lordship,
then
Lordship,
we can dispose of.
Lordship, by that way, Lordship, it can be disposed of.
That the three things.
Lordship, as because
has been mentioned in the notice.
I have that I'll
from
say
the
that.
notice, apparently it is reflected that these three things are not there. By that way, Lordship.
So
And even then, Lordship, if they are occupying
steps
the
will be
government-
taken to recall this notice
Yes,
and to undertake a freeze exercise as per
Lordship.
in accordance with law. That will do.
Lordship, Lordship.
Other
Unnecessarily
Same,
keeping this.
Same,
matter,
Your Lordship.
other it will be pending.
Lordship,
Heard, Mr. S. Islam. Learned counsel for the petitioner. Petitioners. And Mr. J. Henrik, Thomas J. Henrik, learned standing out the Revenue and Disaster Management Department for the response number 1. And Mr. J. H. Sharma, learned additional senior government advocate Assam for the response number 2, 3, and 4.
Most
And
likely
6.
6, Lordship, yes.
And who is PWD? MS.S. Sharma, learned standing counsel PWD for the response number 5. Full stop. It is the case of the petitioner that they are in occupation of a plot of government land within bracket 2G land under DAG number 28/7 at village Ponchorotro NC, Moja, Bali, Jana, Balijana Revenue Circle District, Gwalpara, since about
More than 60 years, 66 revenue.
for more than 60 years by constructing dwelling houses thereon and by paying land revenue, by paying revenue, etc. Toji Bahira revenue, regular. Full stop. The petitioners have approached this court by the instant writ petition under Article 226 of the Constitution of India after on receipt of an eviction, on receipt of an eviction notice dated 27/12/2023, issued under the hand of the respondent number 3, that is Assistant Settlement Officer, Balijana Revenue Circle, Gwalpara. Full stop. A sale is made to the said eviction notice primarily on 3 counts, first, there is no mention in the impugned notice about the statutory provisions under which the respondent number 3 has exercised the right, to issue an eviction notice. Secondly, there is no mention in the notice of the land details, particulars from which the petitioner has been sought to be evicted. And thirdly, under the settlement rules framed under Assam Land and Revenue Regulation 1886, more particularly, Rule 18 thereof, it is only the Deputy Commissioner. Rule 10 amendment resolution. It is only an authority who comes within the definition of Section 3M of the Assam Land and Revenue Regulation 1886, who can undertake such an exercise of eviction. 3M is Deputy Commissioner includes and shall be deemed always to have included additional Deputy Commissioners. That has been amended. Circle Officer has been included. Assistant Settlement Officer, they have to measure the land, not to undertake any exercise. Lordship. Full stop. Both Mr. Hendig and Mr. Verma, learned counsel representing the learned state council, have fairly submitted that the impugned eviction notice prima facie appear to have suffered from certain deficiencies. In such view of the matter, necessary steps would be undertaken for recall of the eviction notice. Full stop. At the same time, they have submitted that the petitioner appears to be in occupation of government land, and as such, any exercise of eviction of the petition from such government land will be undertaken as per the provisions in accord as per the procedure prescribed, as per the prescribed procedure, by initiating a notice appraised, if so advised. Full stop. Having regard on a perusal of the eviction notice dated 27/12/2023 issued by the respondent number 3, this court finds force in respect of the 3 points issues raised in respect of the said notice. Full stop. The deficiencies in respect of the impugned notice on the 3 counts have also been found support from the submissions of the Learned State Council. Full stop. As the Learned State Council have conjointly submitted that the impugned eviction notice necessary steps for recalling the impugned eviction notice dated 27/12/2023 would be undertaken, and a fresh exercise undertaken, submitted that the impugned notice have suffered from deficiencies at least on 3 counts as indicated above. Full stop. In view of the above correct situation obtained the case, and more particular, and for the reason indicated about the deficiencies in the in respect of the impugned eviction notice dated 27/12/2023, this court is of the clear view that is of the considered view that the writ petition can be allowed without issuance of any notice and at the motion stage itself. As the impugn notice has suffered from the deficiencies on 3 counts as already indicated here in above. Accordingly, the impugn eviction notice dated 27/12/2023 is set aside and first is set aside. Full stop. The state respondents are, however, at liberty, considering the fact that the petitioners are in occupation of a government land, the state respondents are, however, at liberty to undertake an exercise for eviction of the petitioner from the same government land, but such exercise must be strictly in accordance with the procedure prescribed by law, but more particularly the Assam Land and Revenue Regulation 1886 and the rules framed here.
Next two methods also
Same.
Same notice.
Details. Where is the details? I am indicating the details. Now you are aware.
Lordship.
What to?
By following the 3 counts, Lordship. it can
Page
be.
42.
Paragraph 2 does it. Right? Mr. Islam?
Lordship.
Government land,
Yeah,
tag number 135. Village sponsor on the Moza so and so, since a long period of time.
More than 1970.
Tozi revenue, construction of dwelling house, right?
Lordship.
Next.
It's para 2, Your Lordship.
Para 2.
Para 2, Your Lordship.
Same assistant settlement officer. Okay, para 3.
Para 3, Your Lordship.
Para 3.
Same notice, common notice.
Same.
Memo also not changed.
Only that district commissioner / district collector.
Okay, district commissioner.
Because we are saying deputy commissioner.
It is
Lordship,
not coming
Lordship.
in the mouth.
Much obliged.
Yes, Mr. Mazumdar. Asian Lakes. Okay.
Admission item number 3.
Please, Your Lordship.
Standing Council, High Court.
He is on his way, my lord. Just
Okay.
outside here.
Okay, we'll come back then. 5 minutes.
Sorry, it just slipped my mind, my lord. I'm so sorry.
Because we want to know the benchmark.
Benchmark, that thing I have, my lord. In the meantime, I got an instruction wherein I got the gradings from 2015 to 2020.
That I have seen.
No, perhaps this has not been placed, my lord. But there is no benchmark, my lord.
Then,
Seniority come merit.
then yes, seniority come merit, definitely. There is no dispute about it.
There is no benchmark.
But thing is that, say, previous 5 years, SCR are to be considered.
Yes.
Then, out of that, for the purpose of the minimum merit, an incumbent should have at least, say, for example, 3 SCRs of having good remarks or very good remarks. That is the benchmark.
Yes, in that.
That has to be prefixed. seniority come merit. Merit takes a subsidiary role. But one has to meet the minimum benchmark on merit, even in case of seniority come merit. And that has to be prefixed. There are procedure. Always. I already, if no appeal is preferred, that is holding the appeal. In a other case, kuntu astu?
Here, my lord, in this case, he was convicted in the year 2018. That conviction was upheld by the district and session judge. And a departmental proceeding was also initiated. Therein, he was.
Whether all these things are recorded.
Minutes, it's not there, but
What is the
ACRs.
minute?
Yes, I have annexed the minus in my affidavit in opposition.
Let us keep the minute.
Page 47, R6. It doesn't say, but it says the gradation list and respective ACR copies are placed before
That will
the.
not do. Such exercise would not stand the scrutiny of law. Which page?
Page 47, annexure R6, below, internal page 47.
47. Resolution. Resolution.
Yes, below. 26/11/2021.
Gradation list and their respective ACR
ACR
copies
copy.
are placed before the selection board for selecting the candidate for the post of civil solicitor.
Yes, ma'am.
Now, what is there after?
And thereafter.
What is there after?
In the next page is the recommendation of the private respondent.
Page 48.
48. ma'am.
What is the method of selection?
Prior to that, if
Say
you
for 5 ACRs, I have seen your instruction placed by another letter.
Lordship.
This one.
Yes, my lord.
See the ACRs.
Yes.
Case of Paul, petition writing.
Yes, ma'am.
6 years are indicated. 6 years have been indicated.
Yes.
Not available.
Yes.
Good. Not available. Average. Good. Average.
Yes.
Right? So out of 6, 1, 2, 3, 4 ACRs are available.
Yes.
Right? Come to respondent.
Yes.
4 ACRs are not available. Only 2 ACRs are available. On what count?
That instruction. My lord, I asked.
One
wrote a
should have
letter.
Mr. Das for the selection committee. There has to be benchmark prefix that yes, we'll consider. We are required to consider 5 previous years ACR. Or maybe 3. We don't know. There has to be prefixed. And thereafter, that one will examine the ACRs of all the persons within the zone of consideration. Then minimum benchmark, say out of 5, one should have at least 3 good in the ACRs. This is the way this merit.
My lord, so far as this benchmark is concerned, my lord, firstly, my lord, it's up to the DPC.
No, DPC has to. DPC after
to correct.
getting sitting cannot decide the benchmark. Just for the purpose of giving some preferential treatment to one incumbent.
If I have understood, my lord, here what had happened, my lord, the ACRs were not available. Perhaps the DPC considered the case basing on the available ACRs, whatever is available.
What tell me?
So if your lordships kindly see, with respect to the private respondents, 2 ACRs were available and with respect to the petitioner, 4 ACRs, of which the recent 2 ACRs.
Your oral submission will not do unless it is supported by some materials on contemporaneous record. Your oral submission will not do just to suit, just to defend the case of the petitioner.
No, I just wanted to place the
Just
things
to
before your lordship,
rebut
what
the
I
case
have
of the-
understood. Apart from
Tell
this.
me the law as regards seniority cum merit. How this is to be assessed,
My lord, minimum merit, rest by seniority.
right?
That is the
How
law.
minimum merit? How minimum merit? Tell me.
In some cases, my lord, the selection
That is the
held-
exact question I was asking.
Yes.
How minimum merit? There has to be something. Here, no exercise of interview, no exercise of any other thing has been undertaken. So it is purely on the basis of ACRs, right?
Right.
Now, we see the pathetic condition of about the existence of ACRs.
True.
Right? Now, say if the benchmark is for, we'll examine previous 5 years ACRs, right? Or we can examine 3. That has to be prefixed before sitting of the DPC,
Yes.
right? We'll examine
Within these
previous 3
parameters.
years. And the parameter would be for merit, at least say out of 3 years, one should have 2 good remarks or 3 very good remarks.
Yes, that is going on.
Then they will proceed.
Perhaps
Just
my lord-
because he has been convicted, then after Prohibition of Offenders Act, all this have come. But question is, at the time of considering his ACR for 2020, he was not served with a copy of the ACR. So that cannot be taken into consideration.
Here,
Law is clear by Devdutt.
yes, if I go.
There is no doubt about it.
If I go by, no doubt about it, my lord. Devdutt is absolutely clear. Sukhdev Singh thereafter also. affirmed-
Sukhdev also is clear.
Here, my lord, going by the minutes, that is my
That
understanding.
is why I asked for the minute records. Your oral
I beg-
submission will not
Lord,
support the.
I'll produce the records, my lord.
That
I
is
beg apology.
because Mr. Das Lawrence Standing Council GAC shall in the meantime obtain the relevant records relating to the promotional exercise.
I missed it.
Oral submission will not be sufficient
I understand.
in this case.
I beg apology.
Only thing that requires to be considered whether a review DPC is to be constituted for the purpose of giving any kind of financial benefit since he has retired. If you look at Devdutt last paragraph,
Yes.
that man also retired.
Yes. Notional.
Notional for the purpose of anything financial.
Financial benefit.
But we want to know that
What was
on
their
what
intent?
count the respondent, the private respondent was, despite being junior, was promoted. And with what benchmark? Out of 6 years, there was no existence of 4 years ACR for him.
Yes.
If you consider 2020,
Yes.
that cannot be counted against the petitioner because you did not provide him a copy prior to promotional exercise, asking for his comment. All exercise were done after the promotion regarding expunging of the remark.
No, that's true, my lord. Lordship is correct. But one aspect is also there, additional, that
Devdutt Sukhdev clears that cannot be by any cost
no.
be considered for promotion.
Look, Devdutt says the ACR has to be communicated. Devdutt says, in the penultimate paragraph, the ACR has to be communicated.
Don't waste the time of the court.
But no, well, I'm not.
If you want to suppose
My lord, I'm not, my lord, differentiating
on that
Devdutt.
count, on that count,
But
on
the
that
on-
count, 1 minute.
Only thing I just wanted to point out before your lordships is that one infirmity the petitioner that he had committed is that the challenge by the communication, the order by which my lord his adverse remark was retained by the appellate authority, that never
No,
came to be challenged.
promotion, what is the date of the order of promotion?
29/11/2021. 29/11/2021.
And what is the date of communication of the adverse entry?
Adverse remark was communicated 6/12/21.
6/12, day after.
True, but
Communicating grade awarded in annual confidential report, uncommunicated SCR not to be considered for promotion.
but 11/1/2022, that order remain unchallenged.
What 11?
By this order,
No.
my lord, average grading was
Sir,
retained.
Prior to the order of promotion, that adverse entry has not been communicated to the petitioner for the year to 2020.
2020.
That by any stretch cannot be considered against the petition. That remains out of them, that remains how many? 5 years. Where is that? Comment? 5 years.
Yes,
Out of 5 years, only 3 ACRs
Three.
were available.
3 ACRs.
2 good, 1 average.
Yes,
And this man has
One
good and
good.
very good.
1 good, 1 very good.
1 very good. Now suppose if the benchmark is 2 good, then petitioner should have stole a march over the respondent.
Yes, in that event, yes.
That is why if
I'll
the
produce the records.
selection committee says that at least there should be 1 very good,
Then it's a different thing altogether.
but then we'll not go into all these aspects. You got my point?
Yes, my lord, I got.
That there should not be any average. Then also, because the petitioner has average, 1 average. This man has 1 good, 1 very good.
Yes.
Then also, but this has to be prefixed. Otherwise, what will happen? Selection committee will sit. Thereafter, they will examine the ACRs.
And will.
Thereafter, they will see, fix the benchmark. Okay, we'll only go for 1 very good. And things can be manipulated.
I understand, my lord.
We got my
Yes,
point.
yes.
Then this will be against the settled position of service jurisprudence.
Here, my lord, I think, my lord, what they have done, the selection committee, instead of, my lord, going for this benchmark, since he was convicted within this last 5 years,
Show me the law. Then
so they have found him unsuitable for promotion.
show me that how this can be done.
In
I'm
fact,
not aware of any law.
in fact, in Janki Raman,
That is
no,
seal cover.
no, in para 28 and 29.
Let us see, Janki Raman.
Yes, ma'am. Para 28 and 29, there were observations by the list of books. Also, can have a look, my lord. What the Honorable Apex Court has held, my lord, that DPC, while considering promotion, can go into the entire service because a person has to be an unblemished service record for getting promotion. He cannot claim as a matter of a right. So the DPC has got the right to consider the service, my lord, service record of past 5 years of the employee and make its assessment. Whether that person is suitable or
Show me
unsuitable.
that.
I'll just this. I do. Huh? No, the list of books kon dikhai diya.
Yes, can you throw some light
Lordship,
as regards your probation of
Lordship,
offenders act?
Lordship, as per Lordship, earlier Lordship, this code itself has with regard to prefixation of benchmark Lordship.
That I have
Yes, Lordship. given.
held.
Yes. And
That is
moreover,
why I want to check the records. If there is prefixation, then end of the matter.
yes, Lordship.
But he is not producing.
Millard, it was my mistake, Millard. I beg apology for this. I just keep the somehow.
Even there is some that yes, because of his conviction,
Yes, yes.
there is he is regarded to be
I assure you,
unsuitable.
Lordship will take up immediately after the beautification.
Unsuitable. Then we can examine that aspect.
True, my lord.
May
That
I
has to
please?
be examined, then rest.
That has to be by the selection DPC,
Yes.
not in the form of an affidavit.
No, no, no. It has to be by the DPC, my lord. Affidavit cannot improve. Cannot improve.
That is a difficulty.
My lord can have a look at para 28 of if 28 and 29. Although the entire judgment is for seal cover, this was subsequently relied on by another judgment in a, and that is Ram Assis Dixit.
It is for you to say because
Yes,
I am
just-
not taking up any service matter for 3-4 years.
No, no, no. It's not like that.
Yes, that is like that. I'm
When
not,
the metal is Millard,
I'm not very accustomed with the latest development.
no, no, it's not latest Millard. It's there, perhaps.
This is Ram Assis Dixit.
This is Ram Assis Millard. It has
Sanjay-
relied on para 10 one notes your lordships can have.
Okay, let us para 10.
It has quoted that particular paragraph of Jantina.
Okay, paragraph 10. Okay. Now, where is that application of mine on that count in the selection record? That will be required
Yes, my lord. That will be required.
for that purpose.
Yes.
suppose
This
they
is
have-
one limb.
one
that's
limb,
it.
they have applied their mind on that count that
Yeah.
yes, promoting the petitioner would be not in the interest of better administration.
Yeah.
There should be some reflection
There
in
has
the
to be.
records that yes, DPC has applied a mind, taken into account the factor regarding his past conduct. That could be a factor which might tilt
Yes,
against the petitioner.
yes.
Otherwise, laws right from as regards the fixing of prefixation of benchmark
That is clear. That is.
for
communication.
even merit, there has to be some standard.
Yes,
On that count, you have not adverted to anything
nothing.
in
I
the
know,
counter affidavit.
nothing in the.
Secondly, there is availability of ACRs are very poor.
Yes.
Poor.
That also, I am also shocked, Milord. Why this? Because this should not have happened. To be very honest, Milord. ACRs, if you don't have the ACRs of a person, an employee, that too in 2023 or 2022, it's not that 2001
After
or 1999.
Devdutt is in 2008.
2008,
Eight.
and we don't have ACRs of that person of 2015.
Of both
it's
the
not-
persons.
It's not a good sign.
6 years
It's not a good
of both
sign.
the persons. See
Yes.
the statistics.
Yes, my lord, 15, 17, and even 2020 of the private respondent, it's not available. It's not a good sign, my lord.
This is not a good sign.
But SCR 20.
Sorry.
SCR 20 to target against the answer if you said that the procedure will not affect into the only SCR 27.
So my lord, I'll produce the records. It will be better.
Mind it, 1 line, 2 line at least should be there.
Yes, yes,
Then your Ram Assis Dixit may be applicable.
my lord.
Or Janaki Raman.
Yes.
Might be.
Well, I was also not aware of this para 28, 29 of Janki Raman. I was always of the view that Janki Raman seal cover, but something different has been said in para 28 and 29.
Yes, Mr. Das, you are only interested in financial benefit now.
Yes, Lord.
That can wait since you have retired.
Yes.
TK Das for the petitioner. Yes, Mr. Rajai, anything or Mr. Mohanto?
My lord, our statement is the same thing.
No. On the present fact situation, it is not likely that your promotion would be disturbed. We are considering the aspect of anything regarding financial benefit with regard to the whether can be considered or matter would be at best matter can be relegated to the authority or constitution of a review and to examine the case of the petitioner for the extending the benefit of whether anything can be whether he passes the benchmark. If passes the benchmark, then the benefit,
Yes,
not by substantive promotion,
Yes, yes.
by demoting you. So as on that, you have no submission to make on merit.
But apart from this, my lord, so far my lord feeding, my lord, cadre is this, my lord. This is the upper division assistant, my lord. The upper division assistant is seniority, that is, I am senior to them.
No,
So because
I don't think.
Because
I don't think.
according to sir, I will get promotion 4 years ahead of his promotion.
No, that has been reversed.
But in case of the, my lord, the junior division, my lord.
No,
Not
that
in the
has-
upper division. Junior division is later appointed, so that was some senior affected.
And so I don't think so, because the state also, the High Court also has said that he is senior.
Yes, yes, my lord, but
He is senior. There is no doubt about it.
But I may be, my lord, wrong, my lord, but so far my understanding is that, my lord, so far the junior assistant is concerned, that was rectified. But later on, he was given a subsequent promotion to me, my lord. Later on, my lord, whenever I was promoted to from junior grade to senior grade, that at that time, my lord, I was get 4 years. ahead of
Gradation
him.
list is there.
And the so far another one.
Gradation list of grade 3 ministerial staff.
Yes, my lord.
Petitioner is above you.
No, he's senior. There is no doubt about it.
It is in a junior,
Additionally is above you.
in junior cadre, my lord.
No. Senior cadre.
Promotion is my lord showing.
Senior cadre. ED assistant. Standing counsel GSC for respond number 1 to 4 and Mr. BB Narajari, senior counsel assisted by P. Mohanto for the marriage counsel for respond number 5. Mr. Das, standing counsel GSC, who was asked to obtain the relevant records relating to the promotional exercise from the post of UDA to civil solicitor
Yes.
on the previous date within bracket 12/12/2023, has submitted that he has not yet obtained the relevant records and has sought for listing of the case after 3 weeks.
Can it be on 30th or 38th
38 will be,
January?
traffic could be too much.
30, madam.
13 to
Because in the meantime, we have a vacation. In the meantime.
13 to
Yes.
February.
Yes, madam.
After
Fine.
1 month.
Fine, madam. Fine.
13 to
13. Fine.
the prayer made by so and so is allowed. Only is the case on 13 to.
Obliged.
Itu video. Itu file video to ini to Kamini Kumar Das to हमने बेलगे तो दी हाँ
Finding item number 2. Sorry, my lord, it was called.
No.
My lord, when I had gone through this petition, there was a query which was put forward by your lordship.
Regarding that
the statute provides.
notice, it will be answered.
Yes, please so cause notice whether it is required or not. Your answer is different. Your lordship was putting a query, whether statute provides or not. This is what. So now I have gone through it, my lord. What I found that in this case, there is their own demand notice where it says that you could not submit those documents which a notice was issued. That's why we are levying a penalty of under 77. This is number 1. I'll show you. Number 2, suppose it doesn't contemplate, statute doesn't contemplate of a so-called notice, then there is a provision under section 83 of this Finance Act, where you can take the help under Central Excise Act 14. This is under the Finance Act. This is number 2, my lord. So if your lordship kindly takes up the writ petition, first kindly see the query which was put forward by your lordship was page 36, 35 is the SOCOS. That is on 26/4/2021. 26/4/2021. Now, if your lordship turn to page 36, this is what it's, where it appears that notice was asked to submit certain document while letter dated 4/9/2020 for asserting his actual service tax liability during the financial year 2015-16, but he failed to submit the same till date of issuance of this notice. What was your lordship's query that whether it is a mandatory provision under the statute to issue a notice? Now, if your lordship, this notice item specific averment that neither we have acknowledged, lordship has seen that. Now, kindly turn to page 38, ma'am. Page 38. Now therefore, third paragraph. Now therefore, so and so is called upon to so cause a joint additional commission of central GST and so within 30 days from the receipt of notice as to why. Number 1, service tax amounting to 1 crore so and so for the period should not be demanded and recovered from him under provision 73 of so and so. Number 2, applicable interest on the amount of unpaid service tax should not be demanded, recovered from him under 75 of the Finance Act. Penalty should not be imposed under section 77 of the Finance Act 1994 for failure, kindly word, for failure to furnish the information and produce documents requisition by the department. This is what I am on. So if that be the case, the starting point will be 4/9/2020. This is, and whatever the last occasion he has produced, that is, of course, it is not, this is not a part of it also. That's why Lordship has said whether it is a part of it. Because on the, for failure to furnish information and produce document requisition by the department. And 36 is the notice. 36, kindly see my lord. 1 second, 36, that is this third paragraph. There where it appears, notice was asked to submit certain documents so and so, 4/9/2004, asserting his actual service tax, so and so, but he failed to submit the same. So, my lord, this is where I have not received also. So how 77 is not attracted, my lord, in this case? 77, they said that you have failed to furnish. And whatever 77 penalty is in connection with Roman 1 penalty because of 1 crore 34, they have levied. Now, if your lordship kindly see 77 for a moment, kindly see the statute, that is chapter 5. I'll tell your lordship one thing. There is one judgment of this court where it is under 73(1). I have gone through it. Then pre-show cause notice is not mandatory. One judgment of this court. It says that if it is 73(1) proviso, pre-show cause notice is required. This is judgment I have read, my.
Because
but when you resort yourself that there is a notice 4/9/2022 seeking certain documents, my lord, from your demand notice, then definitely, my lord, the option was that you should have served.
because in say 73 of the GST Act,
Yes.
this is to be
My lord, I'll tell your lordship, my lord, one thing. There is a circular. There is a circular which is says if it is 73(1) proviso, pre-show cause notice is not required. Let us be very honest and fair to it, my lord. So cause is not required. That is why when it came up before this court in one of the matter, it has clearly said that pre-show cause notice is not required.
because say in case of GST Act,
Yes.
say it is 73, if it is 73,
Yes.
it speaks of a notice, show cause notice.
Yes.
Now, suppose it pertains to Mr. Cal, it is 66, right?
Probably 66.
66. Suppose it pertains to 66.
66. 56.
Ah,
Your lordship is looking.
that is, that contemplates prior notice, right?
Yeah.
66. And that if that is read with Rule 99
Yes.
of the CGST Act, then there is a prescribed procedure
Right.
prior to that show cause notice. To form the opinion, there are prescribed procedures that form this thing. There's, for example, GST ASMT is to be served, then he has to reply, SSC has to reply. Thereafter, this assessing officer has to form an opinion. Thereafter, if not satisfied, then only he will issue the notice under show cause notice. So prior to that, the formation of an opinion that this man has committed something, that cannot be done. In the CST Act.
Yes.
That is why I asked that
But
this whether
Service Act-
49/2020, is it a mandatory
That's
provision?
why, no,
It
what
is-
I'm saying, my lord, it relate to 77. Section 77, kindly see. Section 77 of the.
Right, that
Finance
is
Act.
what. You have been asked to show cause as to why you have should
My
not
lord,
be
my lord, I,
impose a penalty because of failure on the part to submit the information.
that's why I'm saying,
Right.
so what I'm saying, that my lord, there is no question if they would have served a notice on 26/4/2021, which is when put to challenge, not referring 4/9/2020.
Whether this you have just shown
Yes,
page
36
uh,
and 38.
36. That would be a matter which would call for examination, whether that would amount to the violation of
Principle of natural justice. No, why? Under the statute, my lord, under the statute of Finance Act, if your lordship kindly see 77. Not only the 77 clearly states 77 penalty at 23, down below 23. Penalty for contravention of rules and provision of the act with no penalty specified. See, kindly see, man, who fails to furnish information called by an officer in accordance with the provision of this chapter or rules made thereunder or. So this is what, my lord, if you see at page 38, this is what it says, my lord. There's certain information, notice was issued to you to furnish certain documents, you could not produce it. Therefore, my lord, we penalize you, penalty under 77.
Now that's C.
Yes,
Now, what is in accordance with the provisions of the chapter or rules made thereunder.
yes,
Now that 49, whether that is traceable to any statutory provision.
yes.
This might be that
No,
that
83
penalty
kindly
might be
see.
wrong.
See, kindly see 83. See 83, my lord. 83. Page 26, kindly see. Page 26. Page 26, section 83. Lordship got it, my lord. Application of certain provision of Act of 1 of 1944. This provision of the following section of Central Excise Act 1944, as in force from time to time, shall apply so far as it back in relation to service tax, as they apply in relation to a duty of excise. Now, if your lordship kindly see all the section 14, kindly see 14, my lord. Lordship will kindly mark 14. 14 of the Central Excise. Now, if you see 14 of the Central Excise
Central
Act, my lord. अरे मान रहा छोटा बुक नहीं है मान बड़ा Section 14, my lord, of the Central Excise. Lordship got it? 14. Power to summon person to give evidence and produce document in enquiries under this act. Any central excise officer duly empowered by the central government in this behalf shall have power to summon any person whose attendance he considers necessary either to give evidence or to produce a document or any other thing in any inquiry which such officer is making for any of the purposes of this act. A summon to produce document or other things may be for the production of certain specified documents or things or for the production of all documents or things of a certain description in the possession or under the control of the person summoned. All persons so summoned shall be bound to attend, either in person or authorized agent, as such officer may direct, and all persons so summoned bound to state the truth upon any subject respecting which they are examined or make statement, and to produce such document other thing as may be required. So under the Finance Act, that is not present. So this is why the specific section 83 empowers, which is not in the Act, under the Finance Act, they can take the help of the central excise. And your lordship kindly see, that's why they are aware of it. And I mean penalized under say 77 for non-furnishing. And they said that I have already furnished, or notice has been issued to you way back on 4/9/2020. Specific averment has been made, we have not received any notice. My lord, this is the area where, my lord, I have not found any or any judgment from this court on this subject, 83. There is an order passed judgment of this court under 73(1) proviso that no so-called pre-so-called notice is not required. But this is the area where, my lord, I found it, my lord, subject to correction by your lordship, and of course my learned friend.
The 73 proviso, it
Yes.
deals with that 5 years.
5 years, correct. 5 years. Well, what they could have, just hypothetical, my lord, they could not have issued the notice on the notice on 4/9/2020, because they could have straight away the notice which they have issued on 26/4/2021 directly they could have issued, saying that this is what we have, 5 year limitation. Where is the question of issuing a so-called notice to you? Why they have issued this? That is why 77 kindly be seen, my lord. The penalty that you have to furnish the information. This is what, my lord, it contemplates, my lord.
In the type copy of the demand notice,
Yes.
something has gone missing.
Yes. Right. I also have checked it, my lord. Your lordship, absolutely correct. For that, my lord, original is there, my lord.
Original is bit
Yes.
E.
Yes, we have
Eligible.
also gone through it. I extremely apology for that page 42. This is the original, my lord. 40,
40.
42.
Something has gone missing, say for paragraph page 35,
Yes.
second
lordship.
paragraph,
Right.
mention of this section 1 for something 194
Yes.
has gone missing.
Yes. So, my lord, 40, you'll kindly see original, my lord.
That is bit illegible.
Yes. That's why we, if necessary, my lord, we'll proper type copy, my lord. This is also eligible. I am sorry, my lord, page 43. Lordship is right. I was asking myself that why this a notice 49? They could have issued a directly, which they have done it 26/4/2021. Because if you exercise 73(1) proviso, then there is no question of any so-called notice, pre-so-called notice. No, it is not required at all. Because of furnishing the document, that is why they have issued this notice on 4/2/2019. They said, supposed to be, and which we denied. They said, we have never received such notice. Four nine 4/9/2020. Type copy
Now then, you have been imposed a penalty of 10,000 for non-compliance of 77.
77.
Now that could be a ground in the appeal. Suppose you have taken that ground in the appeal.
What at
Where is your appeal?
70 kindly see. Grounds of appeal.
Appeal.
Grounds of appeal page 70. 2.0.
Yes,
2.0.
2.0.
0.
Was never received.
Yes.
That was a ground urged in the appeal.
Yes.
That appellate authority might not have considered that.
That's why it should be.
Whether that could be,
No, it can be.
that could be a ground to prefer a writ petition under Article
No,
26.
then, my lord. if
Because
it is-
this
Yes,
has
right. Your
already been
lordship is right. My lord, your lordship's area is very circumscribed, very
very
limited.
circumscribed.
Very circumscribed, very limited.
That ground you have taken.
Yeah, I have taken. Now, this was a ground which was a principle of natural justice, which no so cause was issued. But today I have come up before this court on the ground that there is a principle of natural justice because no notice. That's the issue, the initiation of the demand note, of the notice which was issued.
Three things have
Suppose.
emerged.
Yes,
That they are saying they have issued a notice.
yes,
You have said that you have not received the
Yes.
notice. You never received a notice.
yes,
Then penalty of 10,000 was imposed.
yes,
A ground was taken in the appeal and urged before the appellate authority that was not dealt with. Whether this ground cannot be dealt with the
If
next
it-
appellate
No,
forum,
no. Well, my lord, if it is a principle of natural justice,
then
which is the starting point.
everything will go
No,
on prejudice.
No, then what will happen, my lord? Suppose I am telling your lordship, this ground, then it goes back, this is my submission because before your lordship, that it goes back again to the first court. If it is a principle of
comes the
natural
issue.
justice.
You have claimed that was never received. They have said that they have
My
served.
lord, this will,
We will not go into that
No,
service of notice.
no, my lord, it's a principle of natural justice is the only ground, one of the 4 grounds where your lordship can interfere. Even if there is a remedy. That I think your lordship, that's the
would
point.
require again factual thing.
My lord, we agree to that only to the extent that High Court can interfere if there is a remedy also available. If there is a 4 condition is violated, then your lordship can look into it. Now, first condition is the principle of natural justice.
Right.
Now, now, my lord, kindly see this what your lordship will. This is my humble submission. Your lordship will not pass. Your lordship will send back to decide the issue on the commission of appeal. This your lordship under 226 alternative remedy is already efficacious remedy is there. So your lordship can send back. Your lordship is not passing any judgment to the effect. Send back and decide the deal. Now suppose tomorrow it decides, my lord, commission appeal. You have received a notice. Then I cannot come here. I have to go before a tribunal. I have to go before a tribunal, my lord. But that part is not being decided. And secondly, but the point is about the violation of your lordship has asked where is the provision that the starting point was 4/9/2020. On the basis of that, we have averment has been made. And today also, my lord, if they show before the court that 4/9/2020, they have received acknowledgement. At the end of the matter, my lord.
No, who will determine service, non-service?
They will have.
Why should we go into that aspect in rejurisdiction?
No, my lord, your lordship in respect.
Counter claims that they have served
No.
and you have said, I never received.
No, that's not a dispute. That's what I am saying. 4/9/2020, that's what was a mandatory on their part. We have said. So, well, they can produce the record before the court. Your lordship can look into the record. There's not a claim or counter. Your lordship can look into the record. That's what your lordship on the very first day, second day, your lordship asked, we want to, please produce the record, we want to see.
Because I am also not conversant with all
No,
this.
no, I'm also, my lord.
Because whether it is backed by any statutory provision,
lord,
next day it came to my
lord,
mind.
Any submission, I don't know, to extent, let's not go a wrong way, my lord, it should not go. Some precedent, my lord.
Because in revenue matters, things are very much circumscribed.
But there are cases, I have seen, my lord, there are cases also, the apex court on the basis of that said that no, if it is your lordship, the principle of natural justice,
Yes.
My lord, whether,
What facets of
no, my principle of natural justice on the very first stage that you said 77, I impose a penalty because we have served some notice to you, certain documents to be produced. I said you have not done it. This
is not-
doesn't,
No, they have claimed that notice has been served. And you have denied in your reply that notice was never served, 4/9/2020. Then this order in original reflects that he has imposed a penalty of 10,000 for violation of 77, right? Then that matter was taken to appeal. Appellate authority did not deal with the issue.
so your lordship on a 226,
So
your
that-
lordship on a,
Which is already
I-
within the province of the appeals. Whether this writ court will
Only-
enter into those aspects
only
which can be gone into by the appellate.
I'll just
authority.
give an, I can just give an answer if your lordship permits me.
Uh.
Your lordship is not deciding the entire issue of the matter. Your lordship is only to the
No.
extent, that on the face of it, only to the extent that there is you did not decide because that's the basis of principle of natural justice. Please decide that on the point of 4/9/2020.
Right. That can be also an issue. It is not that this court is the only forum which can decide the issue. There is already an appellate
No,
forum.
maybe, my lord, I am not saying that.
Appellate forum, which is adequately empowered.
My lord, when I first started the case, I told that there is a forum. First starting point I told, there is a forum. But to what extent the High Court can look into it under 226?
Yes.
That's the issue. My humble
But
submission.
we'll make a deeper probe to find out all these aspects.
My lord.
When an appellate, had it been a case, because the today's, say, item number 1, we are faced with a issue that conviction and sentence has been passed. There is an appellate forum. That appellate forum.
Oh,
But appellate forum has not been constituted.
that case about regarding about land
Then-
grabbing. Land grabbing.
Land grabbing. Then, in the absence of, the appeal is a creature of a state.
Yes, yes.
Then the state, suppose, has not constituted the forum. Then we will exercise 226 or 227.
Yes, yes.
Right. And thereafter, in the absence of appellate forum, to what extent we can go into it? That can be examined in writ proceeding because appellate forum is not available.
Yes.
We might go into the evidence.
Right, you can, your lordship can.
Right. But here, this case is not like that. There is an appellate forum provided by the statute.
Oh, it's right, I agree to it. My lord,
That
but
is the difficulty.
it's not that the power has not been given to your lordship by virtue of 226. That
Power
power,
is
even in spite of there is a provision of an appeal tribunal to be, because a statutory provision has been provided under the statute, even your lordship can exercise under 226. Can exercise to the extent of 4 conditions. It was Whirlpool was 3, thereafter later it was 1 more it was added. I have to satisfy your lordship of this
Out
4
of
conditions.
4, only 2 have been urged in this case.
Yes. But
173 proviso,
yes.
that is regarding jurisdiction. Secondly, the principles of natural
But
justice, which is a
more
broader
but
concept.
more I will say about the principle of natural justice than the point of jurisdiction. My lord. Now, if your lordship decide on the point of jurisdiction, then the principle of natural justice automatically will go. My lord, this requires, this is 83, whether it is applicable, not applicable, this requires more consideration. by
Yes,
this court.
anything to throw on light.
Lordship,
But their judgment, once again, their judgment of this court is there. I telling your lordship, pre-so cause notice under 73(1) proviso is not required. But it was sent back. Again, it was sent back.
To whom?
It was sent back to the authority. Let's see.
Let us see, have a look.
Let's see first.
There should not be any inconsistency also.
Are you are person? Is what?
No, no.
Where is the
Hey, Harry.
judgment of you?
That's it.
100 times dikha hai humko, you are not getting it. 100 times dikha hai. It is not going to Let's see. और फोटो देखा बोला well, I just handing over the copy. You show me from your laptop iPad. मैंने सही करके let me see.
Which paragraph?
The last paragraph, I'm sure, last paragraph, let me see. It says send back to the adjudicating authority. Last paragraph.
No, regarding that pre-show cause notice.
The pre-show cause notice is there, my lord. I just. It's not required, I think. I'll just mark it, my lord, if your lordship wants. They said that we have not received any so cause notice. Then the court said a 73(1) proviso doesn't contemplate any pre-so cause notice. Our case is that you have issued a so cause notice on 4/9/2020. And 77, you have levied a penalty. Their case difference is that, my lord, he argues that no so cause notice was issued, 73(1) has been, proviso had been invoked. Say the court said is not required.
Para 11. I think this judgment is rendered at the stage of show cause notice.
Yes.
We have crossed many stages.
No, that's true. That's why I'm showing it. What I'm showing it, my lord, here for the purpose of the judgment.
Because nothing has been by the no order in original.
No.
It is at the stage of issuance of
So cause notice on like as 26(4). But their argument.
There only the issue determined that that pre-show cause notice for exercising power under.
Whether it was required or not, is not required. So
Not
ultimately, it was sent again to the adjudicating authority.
Because otherwise, on a privacy view, that suppose this jurisdiction, now certiorari jurisdiction.
Yes.
If the authority or tribunal, any adjudicating authority or tribunal, it has exercised a jurisdiction not vested in it, or has exercised something beyond its jurisdiction, or a jurisdiction which was not at all vested in him in all those cases.
Yes.
And so for 73 by the proviso, something has been vested, some jurisdiction has been vested regarding extension of period up to 5 months. How he has exercised,
Yes.
what region he has assigned, that on a subject to correction is not within the jurisdiction of such your right. He has assigned some region. Jurisdiction, because this also supplements my tentative view that paragraph 11 last line, the power so exercised by the authority is a statutory power conferred by the respondent authorities under section 73 of the Finance Act 1994, and as such the issuance of the said so-called notice cannot be said to be without jurisdiction. Now coming to the question whether there was some suppression of fact, the realm of Finance Act, this court would not like to go into the aspect. So basically, the jurisdiction issue and natural justice, these 2 points are urged.
My lord, more than jurisdiction, then will be principle of natural justice. I think that's the issue in the present case. More than the jurisdiction, because if your lordship see the jurisdiction, that only with the jurisdiction, he doesn't have any power also.
Then
Some power is wasted. Then your lordship can under 226. That's what the judgment of the Supreme Court. He has got some power. It's not that he doesn't have the power to exercise. But for establishing, that's again the problem will come because of judgment. Suppression of facts. Now, suppression of facts, whether he has to accept because he has to exercise his own mind to come to issue a so-called notice saying there is a suppression of facts. Because he has to establish suppression of fact, it is they have to establish that there is a suppression of facts. Burden lies to them, not to us. My lord, leaving that part, my lord, what we are on is about regarding the principle of natural justice. Whether your lordship under 226, whether lordship at this stage, whether your lordship can interfere or not, by sending it to the Commission on Appeal to decide the issue. That's the whole and substance of the case. Or your lordship will say that no, 226 we don't have. You can raise all these points before the tribunal because there is a tribunal. I know, you have an eye. I don't know. Where is that? I think one of the judgment of the Supreme Court pilot, 2021, 2020, 13 SC has made scope a bit of wider. Kindly see the judgment, my lord. At paragraph 23, my lord. See paragraph 23, my lord.
This is
21,
Maharashtra.
yes, 23, my lord. This brings us to question whether clause 21 itself creates a legal bar on the Bombay High Court exercising a jurisdiction. As discussed above, jurisdiction of High Court is fundamentally discretionary. Even the existence of an alternate adequate remedy is merely an additional factor to be taken into consideration by the High Court in deciding whether or not to exercise its jurisdiction. This is in marked contradiction to the jurisdiction of a civil court, which is governed by statute. In exercise its discretion to entertain a particular case under Article 226, a High Court may take into consideration various factors, including the nature of injustice that is alleged by the petitioner, whether or not an alternate remedy exists, or whether the fact raise a question of constitutional interpretation. These factors are not exhaustive, and we do not propose to enumerate what factors should or should not be taken into consideration. It is sufficient for the present purposes to say High Court must take a holistic view of the facts as submitted in writ petition and make a determination of the facts and circumstances of each unique case. So there is some scope which is given to the High Court, depending on the facts and circumstances of the case. Whether your lordship, on the basis of judgment, your lordship will plead, this is a unique case, and decide this particular issue. There are few other judgments also, which I like to project if your lordship
And
takes
just
it another date on this issue.
entertaining writ petition in regard to revenue matters.
Yes, I will just.
These are on slightly on a different pedestal. Not unlike this contractual obligation or something like that. This Maharashtra Association, this court has also relied to decide upon a money claim.
Yes.
I have exercised that, not going into that aspect. We can exercise because of Maharashtra State Association. But so far as revenue matters are concerned, because there is a set of hierarchical, there is a hierarchy. And those are considered to be adequate. Now, these four factors will be.
We will look into it, some revenue matters in this context, my lord. Today may not be possible.
We may decide on something else, because this code is also not available for 3 days. It can only be
Come up
after
after
vacation on 18th.
Yeah.
18, 19 or 20, 19.
19.
19.
Let us be on 18.
Okay.
So that I'll have the brief it entirely.
If it is not inconvenient, your lordship, after 18, any date which is inconvenient for the.
Okay, Mr. You will be there?
First of will be there.
You make a mention that. Because I am fixing it on 18, because that holiday will be available. I'll go through the entire.
If some, your lordship will just.
Then we'll accommodate as per.
Yes. Yes.
As per your submission, we'll accommodate. That will do?
Lots of.
Okay. Heard, Mr. Didas, Senior Counsel, K. Talbot. Tamuli.
Yes, Dr.
Okay. Tamuli. Where is MS Fukan? I have been recording her name every time, but since 1 month I have not seen. We'll stop recording as a proxy counsel, SC Cal, GST. The parties, learned counsel for the parties have sought for listing of the case after a week. List the case accordingly on 18/1/2024. Next day, till the next day.
Much.
Much.
Some other person's beneficiary, according to circle officer, has been paid loss.
Paid.
But as per the DAG number, the petitioner is the only person possessing. Then it has to come by way of an affidavit. So that
But
paid to whom and
your document,
lordship.
their document reflects Indra Saw.
Indra Shaw. If it is
You're not
paid
Indra
to,
Saw.
I am not Indra Shaw. If it is paid to Indra Shaw, the matter is different. But
Other
if it is paid to some other person,
Other beneficiary lordship kindly peruse my parawise comment 13, 14 and
Indra is
serial
the
number
name of the
51.
Pattadari. Your Lordship.
Because we fix the matter, if the money is not gone
Yes.
out,
Yes.
then some relief.
In parawise comment, para 13, 14 reply. And in the list, beneficiary 51, 53 and 54 as per my instruction. 51 is Roton Sarkar, 53 is Mumtaz Ali, and 54. But they have not sent any receipt letter from these three persons. I shall produce that after a week. Lordship.
What is that number?
Tag number is 34, Your Lordship.
Patta number?
96A.
Huh?
96A.
Here, synopsis 90, 96, you know?
96. I have annexed the Khatian also. Annexed 1.
96 or 90?
That is a typing mistake in the first page.
Huh?
It's 96. Lordship will peruse the
90A.
notice. Peruse the notice.
90A.
Page number 25, Your Lordship, is the notice. In the schedule, Your Lordship, tag number and pattern number.
Bag number 34.
34.
Admittedly, the notice was issued in the name of Indrosaw.
Indrosaw is the
And the award was also in the name of
Indrosaw.
Indrosaw.
Yes, Your Lordship. Lordship may peruse page 17. That copy is at page 16, Your Lordship.
In this list, what is the serial number?
They said 51, 53 and 54.
50?
51, 53 and 54. Naam tang nahi, dosa number.
What is the name of the village?
Name of the village is Srirampur number 1. Part 1.
Things are not telling, matching.
Lordship, that's why I'm also asking them to provide me some other documents also.
In this award statement or list of beneficiary, all these lands are categorized as private lands.
Private land.
And rag number 34, patta is something else, maybe. Rag number is 34. Name is Rotan Sarkar Mumtaz Ali.
They are saying that beneficiary. As such, the compensation of the said acquisition has already initiated.
Ratan Sarkar and Momtaz Ali, DAG number 34.
Received by the actual legal beneficiary.
How can Indrasa's
Lordship. Lordship.
descendant can be Momtaz Ali,
Lordship, I also.
Ratan Sarkar?
Lordship.
And here circle officer making comments that these are government land. Is it not?
Government land.
Huh? Or
Ekshana
para 2, it says that Indros Prasad Shaw is the name of the pattadar for landed property covered by DAG number 34, patta number 90A. He has said that like that.
Lordship.
Then he says eligible people who were issued notice for receiving compensation were provided with their respective amounts after following due process of law, and the same have been kept on record. Petitioner herein does not fall in the list of beneficiaries, as the possession of land for which he has claimed falls under Indian Railways, and there is no valid ground for compensation. He says compensation for the said land is given to the actual owner of the land being matter of record. Then compensation of the said acquisition has already been initiated and received by the actual and legal beneficiaries. He, in his parawise comment, mentions the name of Indra Prasad Shaw for DAG number 34,
Lordship.
patta number 98. On the other hand, list of beneficiary,
Name.
there is something else. Nothing. Indra Shaw is nowhere,
Lordship, let me.
nowhere found or found. Money has gone out.
Lordship.
No,
And
no.
the names also don't tell you. If your lordship peruses page 26, your lordship of the writ petition,
How can we decide all this now?
to whom it has gone out, it's not sure. your lordship.
He is not saying in clear terms.
It appears
Let them file affidavit then. We thought that,
I
but
am still in
no
possession.
purpose will be served.
I am still in possession of it, your lordship.
You have said DAG number 34, patta number 90A
Lordship.
in your petition.
Lordship. The notice also, your lordship, at page
90A.
96, it will be, your lordship. I think it's-
How can it be? For paragraph 2, you have yourself mentioned 90A.
Lordship.
Page 20 also he has right 90.
Page 20 also 90A.
And in
On the basis of your statement in paragraph 2, notice of motion was issued by the Korean bench, making clear mention about 90A. In your synopsis, 90A.
Yes, Your Lordship.
and Lordship kindly peruse page 25, vernacular patta number AP 90.
AP, that I don't know, 95 or whatever.
And in translated, not given the.
In your synopsis, it is 90A.
Yes, sir.
Paragraph 2, 90A. Then page 20, 90A.
Page 20.
And accordingly, notice was issued.
Yes, Your Lordship.
Petitioner claims to be a riot with regard to a plot of land covered by DAG number 34 and patta number 90 at village Srirampur.
Oh, yeah, 95 AP. But in 25, I think it is 95 AP within bracket AP.
Maybe, but page 26 is the award.
95.
Serial number 229.
Serial number 220.
Indra Prasad Shaw, that is the award. If that amount is rupees 14 lakh 49,000, this is private land. Nature of the land is private. Already award has been decided. Then come to page 25, National Highways Act. This is under 3H2.
3H2. Yes, Your Lordship.
And he says money has been disbursed.
If there is a dispute regarding, there is a provision in 3H2, Your Lordship, it has to be
3H2,
referred.
no, come to page 25. This notice itself is 3H2.
Is under 3H2, Your Lordship.
The money has gone out.
If there is a dispute regarding who is the actual beneficiary, Your Lordship, the Kala has to refer it to the civil court, Your Lordship.
Where is your representation?
Lordship, they did not give a receipt.
No,
copy.
you don't have representation.
I have,
Filed before Kala. You have straightly come to
Lordship,
this court.
Lordship, in paragraph 4, I have stated that I have submitted the documents.
Documents submitted, there is no representation also.
No representation because they did not give a receipt copy, Your Lordship. Para 4, I have stated
You are at
that.
liberty to file application before a Kala. If you, at best, as a tenant,
Lordship. But if the money has been given to somebody else, Your Lordship, whose name does not appear in
we
the.
cannot recover. We are not here for recovery of
I
the
understand.
compensation amount, Mr.
I
Mukherjee.
I understand, Your Lordship. But at least
If
an
that
affid-
man has submitted indemnity bond,
an affidavit from them maybe.
why we should do that exercise?
I'll be aware as to who has.
Why?
received the amount.
This is not for right to
understand.
information forum.
I understand, Your Lordship. But
We are not here.
I understand, Your Lordship. But it just came.
We are
to
not
me-
right to information forum. You get the information.
I
If you are aggrieved, if you are person interested, if you are have a claim under 3G2, person interested, at least 10% of the compensation amount you may be entitled. Otherwise, 3H3 you avail. But why you are exercising this without going into that? First, you obtain the information. You got the notice.
Yes, Your Lordship.
You should have obtained the information. At least you should have claimed.
Para 4, Your Lordship. I have submitted all the documents, Your Lordship. Para 4 of my writ petition.
You filed representation before the Kala regarding your claim. We are not here for right to information forum.
I understand, Your Lordship. The jurisdiction is very much. But Lordship,
Money has gone out,
it has just came to me, Your Lordship. Just now I came to know that money.
and we are not here as a recovery tribunal.
I understand, Your Lordship. But rightly or wrongly, if it has gone out, Your Lordship, I will take some instruction as to whom it has gone out. I'll maybe in the
File
meantime,
RTA application before Kala,
I'll in the
get the
meantime,
information, then you file the claim.
in the meantime,
That man might have submitted indemnity bond
Yes,
at the
microphone.
time of receiving the compensation.
Lordship.
We are not going into those aspects. Why? We should
I understand, your
discuss.
lordship. In the meantime, I'll file a representation, your
You
lordship.
find a
If
representation.
your lordship pleases, they may file an affidavit, your lordship. It will be,
We will not prolong this kind of unnecessary exercise. When you have no legs to stand.
in that case, your lordship, their instruction may be recorded in the order, your lordship, so that I can.
Money has gone out, we will record.
Yes.
Indra Prasad Shaw, he has stated,
Indra
he has
Prasad-
stated in his parawise comment that Indra Prasad Shaw is the name of the pattatar for landed property covered by DAG number 34, patta number 90A.
Agreed, your lordship.
An actual beneficiary has been given the compensation.
Lordship, I have annexed the Jamabandi as well, your lordship. The Khatian, your lordship. Of Indra Prasad Shaw, which shows that, your lordship, I am.
You
the-
are late to board the bus.
Lordship, the Khatian, your lordship, of Indra Prasad Shaw. At page number
Now
70.
he has been given
I
the
understand, your lordship.
amount already.
I understand. I have to fight
We
it
are
there,
not
your lordship.
here as a debt for act as a debt recovery tribunal for you.
I understand, your lordship. But
You are in 226. There is a separate mechanism. Kala, then thereafter 3H3. We are not here for you to undertake that exercise. We have not seen any representation from your side also. In the meantime, money has gone out.
lordship, at least the
Heard, Mr.
instruction may be recorded and my statement that.
Heard, Mr. Vijay Mukhari, learned counsel for the petitioner. Any central government counsel? Mr. Vijay Taludar, as senior counsel listed by Mr. P.K. Meji for response number 2, 5. Miss R.V. Bora, learned standing counsel. BTC for the response number 3, 4,
3, 4, 5, 6 and
6,
7.
and 7. Close. The petitioner, by instituting the instant writ petition under Article 226 of the Constitution of India, has approached this court claiming that he is a recorded riot in respect of a plot of land measuring
11 letters.
that too also disputed. Award says 9 lessons.
Award, they are taking 9 lessons out of the 11 lessons.
9 lessons. 11 lessons of land covered by DAG number 34 and patta number 98, situate at village Sriampur, Kukhaigaon Revenue Circle, District Kokrajhar, BTR Assam, subject to court. The petitioner has claimed that he and his family were in possession of the subject lot since 1950s by constructing an Assam type house thereon and were cultivating a small part thereof. To substantiate such claim, the petitioner has annexed a Rayati Kacha Khatian stated to have been issued by the Assistant Settlement Officer Kukhaigaon on 5/8/18 or 5/4/1976 as annexer 1. Full stop. There is a further case of the petitioner that for construction through widening of National Highway number 127B, a part of the subject land, measuring 9 lessons, came to be acquired for by the by the competent authority in land acquisition Kala, i.e. the respondent number 4 on behalf of the central government, on behalf of the Ministry of Road Transport and Highways, MORTH, Government of India. So stop. The petitioner has approached this court on the ground that the requisite compensation against such acquisition of land has not been received by him. Full stop. Despite making a claim to that effect before the respondent number 4 duly. Full stop. Para. From the notice dated 9/3/2023, annexed to the case papers as Annexure 2, it is noticed that the respondent number 4 had issued a notice in favor of notice in the name of Indra Sao, son of Baburam Sao, informing him that an area of land measuring 9 lessons, covered by DAG number 34 at village Sriampur number 1, Gukhaigan Revenue Circle, have been acquired for the purpose of construction through widening of National Highway number 127B under the provisions of the National Highways Act 1956. In avoid proceedings drawn up by way of a land acquisition case, LA case number 1/2023. Full stop. A perusal of the notice goes to indicate that the respondent number 4 as the competent authority land acquisition within bracket Kala has passed an award, being award number 229, in favor of Sri Indra Sao by assessing and compensation amount of rupees 14,49,623. Full stop. It has been further mentioned in the notice dated 7/9/2023 that the compensation amount has already been deposited in the account of the competent authority land acquisition Kala, and the notice, comma, Sri Indra Sao was required to hand over possession of the land measuring 9 lessas covered by DAG number 34 to the competent authority, and after handing over the possession of the acquired land, comma, the notice would require to make an application before his office for disbursement of the compensation amount of rupees 14,49,623 awarded by the award number 229. Full stop. The petitioner has asserted that he is the recorded tenant stroke Khatian holder under Sri Indo Sao, and as such, comma, the petitioner is also entitled to receive a part of the compensation amount as per the provisions as a person interested and as per the provisions of the National Highways Act 1956. Full stop. As his right of enjoyment of the subject land has been affected in view of acquisition of an area of land measuring 9 lessas wide, LA case number 1/2023. Full stop. This court on the previous date of listing, comma, 3/1/2024, comma, had asked the learned Standing Council BTC to obtain instruction as to whether the compensation amount awarded by the competent authority land acquisition, Kala, within bracket, the respondent of 4, under section 3Z, comma, National Highways Act 1956, has been disbursed to the beneficiary, comma, pursuant to the notice dated 9/3/2023. Full stop. MS Bora, Learned Standing Council. BTC has placed a set of instructions communicated by the respondent number 4,
Tala, yes.
communicated by communication number so and so, dated 8/1/2024 by the respondent number 4. Full stop. As per the pairwise comments annexed thereto, in the pairwise comments annexed thereto, comma, the respondent number 4 has stated that it is Sri Indra Kumar Indra Prasad Shaw who is the patadar in respect of the landed property, comma, covered by DAG number 34 and patta number 90, capital A. Full stop. The respondent number 4 as the competent authority land acquisition, Kala, comma, appointed under section 3 small a of the National Highways Act 1956, comma, as further mentioned that the eligible persons were issued notices for receiving compensation amounts of the following due process of law, and the petitioner herein was not found to be in the category of eligible persons, and as such, comma, his name was not included in the list of beneficiaries. Full stop. The respondent number 4 has further mentioned that the compensation amount so assessed, comma, has already been received by the actual beneficiaries. Full stop. এই নোটিছৰ তাত দিব নোটিছৰ যে এইখিনি যে কৈছিলোঁ the notice dated 9/3/2023 was purportedly issued under section 3H within bracket 2 of the National Highways Act 1956. Full stop. As per subsection 1 of section 3H of the National Highways Act 1956 by Act 56 Act. The amount determined under section 3G is to be deposited by the central government with the competent authority before taking possession of the land. Full stop. Subsection 2 of section 3H has provided that as soon as may be after the amount has been deposited under subsection 1, comma, the competent authority shall on behalf of the central government pay the amount to the person or persons entitled thereto. Full stop. The petitioner herein has claimed that he is also entitled to receive the compensation against award number 229, which has been passed in respect of acquisition of 9 acres of land, comma, covered by DAG number 34, comma, the petitioner should have made such claim, should have lodged such claim at the as per the provisions at a prior point of time, comma, as per the provisions of subsection 2 of section 3G. Of the 1956 Act. Full stop. Since the petitioner has asserted that he has not been served with a notice under section 3H within bracket 2, comma, the petitioner has petitioner has averred that he has not been served with any notice under section 3H2, and as such, Full stop. Considering the fact that the compensation amount assessed by award number compensation amount of rupees 14,49,423 assessed by award number 29 under LA case number 1/2023 has already been disbursed, according to the competent authority land acquisition, to the eligible beneficiaries, the petitioner is required to approach the competent authority land acquisition by way of a representation to substantiate his claim as a person interested in respect of the acquired land compensation amount for which has been assessed while award number 229 and disbursed thereafter. So if such a representation is submitted by the petitioner, the competent authority land acquisition shall consider such representation application query as per the provisions of section 3H3 of the 1956 Act to determine as to whether the petitioner is a person is eligible to receive any compensation in respect of the acquired land measuring 9 lessons covered by DAG number 334. Full stop. In such view of the matter, the this petition is disposed of with a reserving with a liberty to the petitioner to submit an application in a aforestated manner before the competent authority land acquisition that is respect number 4 within a period of 15 days from today. And if such an application is submitted by the petitioner, the respond number 4 competent authority shall consider such application in terms of the provisions of section 3H3 of the 1956 Act. Full stop. After such consideration, the respondents of number 4 shall inform the petitioner about the outcome of such determination immediately thereafter. Full stop. it is observed that such determinations shall be made by the as per number 4, as per number 4, as expeditiously as possible on receipt of the application, but within an outer limit of 6 weeks from the date of receipt of such application. Full stop. This order disposes of the repetition. Anything to be added?
Lordship, one of my submissions, if Lordship pleases, that I am still in possession of the land. It is-
I've already recorded position. You are in position.
My Paravas comment shall be part of the record.
The communication bearing to of the respondent number 4, placed by MS Bora, Standing Council, be kept with the case records.
Bail hearing BA item number 6.
Kind of ask about a matter for timing.
Pass over for the timing. We'll like to rise early today.
Order item number 7.
Yes.
Trial already started and already trial in this case, Lordship already trial also started. So she, the victim girl received a summon also. So we'll withdraw the case.
Okay, not pressing then. Okay. MS Paul, J. Paul,
Yes.
Learned Counsel for the applicant has submitted that. Instruction has been received from the applicant not to press the instant application. Full stop. Or who is public prosecutor? Not available.
KK Das last time appeared. Last time KK
Das,
there.
Learned additional public prosecutor for the respondent number 1, and Mr. M. Islam, Learned Counsel for the respondent number 2 are present.
I am for the opposite party 1.
Respondent number 2?
Mr. KK Das.
Mr.
KK Das.
He is public prosecutor.
My lord.
1.
No, my lord. Here 2, my lord.
No, one. Respondent number 1, he is respondent number 1. And the PP
Okay,
is.
M. Islam, Learned Counsel for the respondent number 1,
My lord.
and Mr. KK Das, Learned Additional Public Prosecutor for the respondent number 2 are present. Full stop. In view of the above submission made by MS Paul, Learned Counsel for the applicant, this application stands dismissed as not pressed.
Highly obliged, your lordship.
Yes, Kyle has come.
Item number 6.
Are they available? Okay. Yes, what are the other cases?
Item numbers 8 and 9 for hearing.
Yeah, please. My lord, matter pertains to exclusion of village from Tiwa Autonomous Council.
Tiwa Autonomous Council.
Yes, my lord. And my lord, as per the Act of Tiwa, my lord, more than 50% of non-Tiwa
Okay, if
person
this would require
be
some
treated-
examination, no, I will not be able to take up the matter today. Yes, Mr. Chudri, it would require some exercise.
Sometimes there is one aspect I must point out to your lordship. In the last affidavit that has been filed, I won't trouble. There is an affidavit filed on 8th of September 23, madam.
In which case?
Number 9.
Item 9.
WBC?
6657 of 2020.
6657.
6657.
Okay. By 1 and 2.
By 1 and 2.
Hmm.
Yes, my lord.
No, it is an affidavit filed by respondent number 3.
3.
Respond number 3, my lord.
One Binita Pegu,
Response number 3.
my lord,
My lord.
Huh.
filed on 8, I think 8/9, no?
1/9.
1/9.
Whatever.
Now, my lord,
Ah,
if your
Binta
lordship will
Pegu.
kindly come to para 6. Perhaps government will have to clarify this position, my lord.
My lord, my lord.
That the answering response, deponent begs to state that the elections to the so-and-so council, including the 6 constituencies, are held in December 20. We are not bothered with that now. Now, after the formation of the new government, the matter has been referred to the cabinet subcommittee under chairmanship of Dr. Ronesh Pegu, Honorable Minister so-and-so, by notification number so-and-so. Now, next paragraph, my lord. That the answering deponent begs to state that the meeting of the new cabinet subcommittee to examine the exclusion of 6 constituencies in the Tiwa Autonomous Council was held on 2/8/23. As per record of discussion, the honorable committee shall submit its report within a period of 1 month. But that 1 month is long gone. We are unaware of the report, ma'am.
This petition pertains to this
Council.
inclusion of this constituency.
Inclusion or exclusion.
So
Because there was a dispute. Just to give you a broad view of the case, they had included these 6 constituencies where, as per the population pattern, it is not justified. Objections were raised. There were several rounds of litigation. There is a division bench judgment directing the chief secretary to take a decision. The chief secretary, while examining the issue, referred it to a cabinet subcommittee. Now, a first subcommittee did not proceed. Another subcommittee came headed by Dr. Ronesh Pegu. Now, this subcommittee, according to the government affidavit, was supposed to submit a report. And that report has not been given to us. What is the outcome of that discussion, or what is
that exercise is completed or not?
No, my lord, my lord. I have a verbal instruction, my lord, from this deponent, my lord, this secretary, my lord, WPT, which is now tribal affairs. My lord, she just sometime back only, she told me that the draft report was prepared and it is now pending before the minister. Means the subcommittee consisting of 3 ministers, that they will sit and then only, my lord, they will finalize it. So, my lord, we need at least 4 weeks time. Let this matter may come up. Government is serious on it, my lord. Only the thing is that this is a very sensitive issue, my lord. That is why, my lord, government is taking all precautions in this matter, my lord. So, a draft report has already been sent to the committee, my lord. So, let this matter may come up after 4 weeks. In the meantime, my lord, hopefully that something is coming up, my lord.
Okay. Dimoria, Digaru, Khetri, Sonapur, Ampri, Hong. You are concerned with these constituencies. There might be positive outcome also. Could
Yes,
be.
sir. If it is a positive outcome, then the repetition itself will become infructuous.
So
we have placed materials on record to show that the population does not justify as per the act itself.
we can wait then outcome if it is favorable to you.
Government is taking steps, my lord. It is not that government is sleeping over it, my lord. No, my lord.
Let them at least
Government
produce
is very
it.
serious.
Draft, it is draft.
Draft, my lord.
That is the problem.
It is very sensitive.
If it is final, then I could have been directed.
That is also true. If it is a draft, then
lots of cuts and things are to be made.
Exactly, my lord. Because whenever there is any move, my lord, the law and order situation of that particular area, my lord, becomes very volatile, my lord. We have to step in so many times here.
But at the same time, when there is a statutory obligation, the act itself says that you have to do it. Last election, my lord, between all this confusion, they proceeded with the election with these disputed constituencies. So at least our concern is that before the next election, at least this should be sorted out. The term is 5 years. So out of that, 3 years is already gone.
Which is the notification by which it was?
Notification, I think, is annexed.
Annexed, right.
Committee last page.
Last page of that affidavit.
Okay. Heard Mr. I. Chaudhary and Senior Counsel is still by Mr. A.K. Burwal and Counsel for the petitioners. And Mr. Ardhor, Standing Council, Department of Tribal Affairs
Travel affairs.
for the state respondents.
My lord, I appear for a Tiva autonomous court.
And Mr.
A Bora, my lord.
A. Borua.
S. Neogi.
Standing, Learned
behalf-
Council representing Mr. S. Navgi, Standing Council, Tiva Autonomous Council. Huh? Okay, then Ms. Tribal Affairs, Kivo. Or and so for respondent, Tiva Autonomous Council, or Mr. S. Navgi, Standing Council, Tiva Autonomous Council, and Mr. R. Dubey. Standing Council. Assam State Election Commission. Closed down. The subject matter of these two writ petitions is inclusion and exclusion of constituencies, of a number of constituencies.
We are concerned with 6 months. In our
Six number of constituencies in Tiva Autonomous Council. Full stop. The Learned Council for the parties have submitted that by a notification dated 4/1/2022. A cabinet subcommittee has been constituted and a matter of inclusion or exclusion of the said 6 constituencies have been referred to the said subcommittee. Full stop. The Learned Council for the parties have also referred to the statement made in paragraph 7 of the affidavit in opposition of the counter affidavit of the respondent number 3, wherein it has been averred that the said cabinet subcommittee held one of its meeting on 2/8/2023. Full stop. Para. Mr. Chaudhary, Senior Counsel for the petition, has submitted that the petitioner is not aware about the outcome of the reference made to the said cabinet subcommittee till date. And as such, full stop. And as to whether the said cabinet subcommittee has submitted its report. Full stop. Mr. Thor, Standing Council, Department of Tribal Affairs, has submitted, on instruction, that a draft report has been prepared, and the said draft report has been sent to the cabinet subcommittee. The said draft report is under consideration of the cabinet subcommittee. Full stop. He has further submitted that he would be able to apprise about finalization of the report by the cabinet subcommittee within 4 weeks' time.
My lord will make it 6 weeks because this week and next week, no, I'm telling you, this week and next week because of Bihu, it will go. These are political people, my lord.
6 weeks.
In that case, my lord, your lordship will fix a date.
Okay. The whole 1, 2, 3, 4. Okay. Release the cases on 19/2/2024 to enable Mr. Dhar, the Standing Council, Department of Tribal Affairs, to apprise this court about finalization of the report by the cabinet subcommittee.
But instead of 19, my lord, let it be on a hearing day. If necessary, then with some
20.
consideration.
20.
20th. Obliged.
Item number 10.
My lord, in this case, my lord, it's a tussle between two departments. Initially, the work order was issued in my favor for 37 lakhs something. Then after completion of the work, the executing authority, that is PWD, they said that do some other works also, additional work. Additional work of 6.5 lakhs around was ordered, madam. They issued an additional tender. Accordingly, I completed them. That part, actually, the work is of work was of NHR, National Health. Now they say that PWD has not taken the sanction from the NRHM. That is the issue. I have executed. In fact, my lord, in the affidavit filed by the PWD, they have admitted the fact. And both the authorities, my lord, they have filed affidavit.
Yes.
We have filed our affidavit in opposition, my lord. Paragraph 6, my lord.
Tell me what is this thing?
Yes, my lord. The Chief Engineer PWD, my lord, filed letter dated 21/2/2009.
Tell me what is the sum and substance? I might be running short of time today.
Yes, my lord.
That is why.
The assessment was done by the PWD, my lord, and work was completed on
Have you admitted that he has done the work or not?
work has been done. Work done.
Work has been done. You are NHM or
NHM.
PWD?
NHM.
NHM.
Yes, my lord.
The work was for you.
Yes. NHM.
Work was for you.
Executed through PWD.
Yes.
Executed through PW. Then why you are not paying? If you are enjoying the fruits of it.
Paragraph 6, my lord, their affidavit, my lord.
Paragraph 6, my lord, last part, my lord.
What does it say?
The work was completed, work certificate was done,
Work certificate issued by whom?
It was by the PWD.
PWD. That was done 27/2010. The enhancement proposal stated to be submitted by the chief engineer on 13/6/2011. That is after a lapse of 1.5 years, my lord, for approval and release of the additional.
The sum and substance whether this work has been done by the petitioner or not.
It's
Huh?
completed. Completed lordship completion certificate has been given.
So it is a case of passing the buck
And verbal agreement.
from A to B, B to A.
Yes.
That is the case.
The internal problem.
Internal problem. Internal problem between two departments.
Department.
What is that decision? Two departments, internal problems between two departments cannot be brought before a High Court or Supreme Court. Who is it? Very specific.
No, in fact,
I may not decide the order today, but and
in
this
identical situation, my lord, what happened in
passing the buck from one to another by two departments of the same government is not permissible.
Not permission.
Verbal agreement হয়েছে তো এটা আমি কই দেব verbal agreement হয়েছে তো
There is one specific Supreme Court judgment.
This is in respect of a case, my lord, pertaining to this Navagraha Road. Navagraha Road was allowed to be completed. Then in between some culverts were additionally done. That was not intimated by the PWD to finance. Then this honorable
This
court-
kind of stands are deprecated by Supreme Court. By two departments before a court of law.
Yes.
More particularly High Court and
in fact,
Supreme Court. That is what, let me be clear, this kind of dispute will arise later on also.
Lord. In fact, matter was intimated by the PWD to NRST. I have enclosed the communication.
This passing the buck by two departments. Mr. Sharma, we are not interested to proceed further today because court will be running short of time. But if this is the only issue,
this is the only issue.
Then we'll fix a date.
Lordship.
I may not be able to complete.
Lordship.
Yes. Yes, MS Sharma. What is your stand? Have you filed any
Department
affidavit?
said that petitioner also stated that the verbal agreement was done. And later they have communicated to the department
In fact, PWD twice communicated.
because PWD is a executive.
What kind of work it is?
It was a building.
Building.
Additional work was the floor. They wanted
Tiles and.
tiles and.
It is being used by them.
Yes, yes.
Very
Build
good.
it.
Had it been something like that embankment near Brahmaputra, it has been washed away.
No, no, no.
It is not that. It is standing still.
Standing still. Sir.
Yes.
Still stand. How much amount? 6 lakhs.
6 lakhs 43,000 something.
And part payment has been made.
Part payment is also made.
No, no, no. That's
Regarding this
6 lakhs is additional.
extended part is not made.
extended part. Other is
Other is paid.
Okay. Hey, Kunya Commerce also. Okay, this case also took 6 years time.
Yes.
This case?
Lordship.
This case has taken 11 years or 10 years.
10 years.
So we're running into 10 years.
6 February.
I think we have lesser number of cases on that.
Obliged.
Obliged.
Mr. S. Sharma. For the petitioner. MSS Sharma. Standing Council.
1, 4, and 5.
PWD 1, 4, and 5. MS A. Bora. Lion Standing Council. NHM for the respondent number 2 and MS M. Bormon. Learned Junior Government Advocate Assam for the respondent number 4. As sought for by the Learned Council for the parties, raised the case on 6/2/2024, considering the fact that the petition is of the year 2014, and endeavor will be made for final consideration of the petition on the next date of this.
Obliged.
Yes, Mr. Bhagavati. Kyle is still not available. What is the main point?
Main point is only
This
today,
court considered
already on merit. it was
thoroughly
Thoroughly.
on the merit of the case.
That was while earlier it
We
was
cannot-
rejected.
We are not in a position
So
to
that
review
Lordship,
all the submissions were recorded,
everything recorded.
advanced by Mr. Kotoki. Reasons are assigned why those submissions cannot be accepted. Now what remains?
The only our petition is very limited prayer we are approaching Honorable Court. That it's today it is the 3 years has been elapsed during from my date of arrest. This is 4th January 2021 and it's 2023 January.
3 years.
We have 3 years completed and by this time only 3 witnesses are being examined.
Okay, now
So-
tell me.
so
Now what is the
trend
likely punishment?
22C we are. So punishment is there.
Punishment, what is the period of punishment?
It can extend to 20 years.
20 years.
20 years.
Now Satyendra Kumar until. What does it say?
So there's a
That is the ground, period of 3 years.
only
You are continuing as under trial prisoner.
prisoner.
Now, rigors of 37,
Is there
that has been discussed already.
already?
Now it cannot be reviewed. Only thing is that 3 years. Right?
Only.
Trial is going on, but it is not going on in a manner expected. Few witnesses have been examined only. And number of witnesses are yet to be examined. Even on that count, this has a relation with the period of punishment. In case the trial goes against you. Now, charges have been framed under what?
22C.
What is the period of punishment?
It may extend to 20 years and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend to 2 lakhs.
Methamphetamine,
Methamphetamine, psychotropic.
codeine, methamphetamine,
Yes, Lordship,
if it is 20 years,
20 years.
then we have to see regarding personal liberty.
Only that count. Because
Vis-a-vis the punishment likely to be faced by the petitioner.
Lordship.
Now there is specific observation in Satyendra Kumar Antil. What does it say?
Half
Where 37
37.
is involved, rigors of 37s are involved. And admittedly, it is a commercial part.
Commercial.
Then what will be the answer? Wow, Satyendra Kumar Antil.
That is difficult, Lordship. That is absolutely,
That remains
that remains,
an obstacle for you.
that is obstacle.
Because on merit, we have already discussed twice,
Twice. On merit, we cannot say, we cannot submit it.
exhaustively discussed. Now, I am not in a position to review the regions again. All the submissions, 3, 4, 5 submissions perhaps, were made by Mr. Kotoki. Those have been
Already
discussed.
Answered.
Now, this petition is only on
Delay count only.
delay count
3
of
years,
trial,
3 witnesses.
3 years.
That much.
That also, Satyendra Kumar Antil also goes against you. Come back. Otherwise, if say 5 years or
One Muslim model case is also, Muslim model case is also there. For that also, in that case, this delay was taken into
there are
consideration.
other cases
There
where
Lordship.
because trial is not proceeding in an expected manner. In the meantime, accused has undergone custody for 3 years, something like that, near about 3 years. Exercising power Article 142, which power is not available, which has, right? So our things are circumscribed by Satyendra Kumar Antil. We are not here to exercise power under Article 142 to do substantial justice. That power is not available. Supreme Court has clearly said they may exercise. So we'll undertake the exercise of dictating if something more comes up, if some distinction has been made from Satyendra Kumar Antil. Small orders will not do. Small 2-page orders of Supreme Court will not do. Right? If something has been distinguished, Satyendra Kumar Antil has been distinguished.
No, Lordship, in this case,
not. Had it been distinguished by some larger banks,
then it would be different.
Then it is possible. But do we have the Satyendra Kumar Antil?
No, no.
Okay, I think half the period.
Half the period. That is maximum.
Where rigors of 37 is
Is
applicable.
There. Minimum punishment, then maximum punishment happen in between.
Intermediate and small quantity, okay.
Is different. But apart from this, they have submitted one affidavit of opposition and they have annexed one High Court order, our High Court order, regarding our co-accused who is also facing the trial with me. So is Muhammad Salam. In that case, this Honorable Court has observed and given a specific direction in respect of that particular accused that it was passed on 18/10/2023. And from receipt of this order, 18/10/2023, The trial court is specifically directed in para 10 in their affidavit. It is page number 11111. That within 4 periods of service of this order, the trial is directed to be disposed of in para 10 of our coordinate benches directed in para 10 of their judgment and order.
There are so many directions that this kind of direction is not called for.
Not called.
You cannot direct the trial court. Yes, it is expected that you proceed with
endeavor can be given.
But
so in that case,
I'll not subscribe to that observation. You don't expect me to subscribe to that observation because this kind of direction
is
uncalled for.
Lordship.
There are many circumstances which might come before the trial court.
That is correct, Lordship.
You can only observe that it is expected that endeavor should be made to complete the trial within reasonable period of time or with utmost expedition. But you cannot fix the time limit.
It's impossible almost.
When the parliament is not fixing the time limit, neither the CF, they are fixing this. So, but court cannot direct. This, I think, runs against directions of Supreme Court. And this court will not subscribe to that view. When it is found that if you want to make observation, then I'll make observation. That will be difficult for the other accused also.
Lordship. It is there. Here's the direction.
If
somehow shall be released on bail subject to stringent conditions.
That I not. Someday else then, Mr. Bhagavati.
Lordship.
কম থাকাটা ডিসপোজ করব লাগবে Kyle is not he is on legs.
He is still on legs in court number 23.
1st February. 1st February, কম আছে? কম আছে? Okay. 1st February. Mr. B. Bhagavati, learned counsel for the accused petition is present. MS M. Deka. Learned counsel appearing on behalf of Mr. S.C. Kyle, learned standing of NCB has submitted that has prayed for listing of the case on another date in view of absence of Mr. Kyle due to certain emergency. So, the prayer made on behalf of Mr. Kyle is allowed. List the case on 1-2. That they will dispose. Until Nikita. And that is Special Acts Category C. 37 NDPS Act referred to. We therefore direct as under. Where the under trial accused is charged with an offense under the Act punishable with minimum imprisonment of 10 years and a minimum fine of ₹1 lakh. Such an under trial shall be released on bail if he has been in jail for not less than 5 years. Not less than 5 years, provided he furnishes bail to the sum of sum. 5 years is the minimum.